Good morning or good afternoon. My name is Lakshmi Challa. Welcome to our weekly COVID updates for employers and foreign workers. I'm just going to give folks a second to log in and join. I hope everyone is practicing safe distancing and are doing well. These weekly seminars are geared towards helping the general public understand all the changes that are taking place within the immigration spectrum. And it seems like weekly there are, new developments in immigration. So we wanted to provide a platform where we can help folks better navigate through these new changes. Last week, today what we're going to do is recap a little bit of last week. And if you didn't catch last week's webinar, then I encourage you to check out our YouTube channel and subscribe if you like it. And so that way you can catch up on some of the things that we've talked about previously. Each week we're trying to take a deep dive into one particular area and, move forward with, updates that have come up. So in order to, this week we're going to try to really focus on, number one, the President's Proclamation, and number two, how, changes in, the reduction in workforce could impact your permanent residence processing and so forth, and some public charge concerns. So our focus this week is going to be on the permanent residence process. So a brief recap of last week. We talked about the H-1B specialty occupation, some recent court cases, because now employers a lot of them are going to be processing the H-1B petitions for cap season. So we wanted to make sure that we highlighted some of the court cases that would, could impact the processing. So like I said, if you want to understand more about the cases and how it can help you in this H-1B cap season, then please check out our YouTube channel and you'll get the latest updates. And we basically talked about the H-1B specialty occupation before. So now last week, everyone was stunned and concerned when the president tweeted that he would initiate a new travel ban, a new immigration ban, restrictions. He's allowed to do that under the 8 U.S.C. 1182F of the INA, where the president can bar entry when it's detrimental to the interests of the U.S. So that's where we start. Oops. So the overview of the President's Proclamation. To give you a quick understanding, he signed the proclamation April 22nd. So it impacted immediately those people who are outside the United States of the effective date that did not have, and basically targeting immigrant petitions, not non-immigrant. So temporary visas were not impacted, but it was just the immigrant petitions, certain immigrant petitions that were impacted. And not those that are in the United States, only those who are outside the United States did not have a valid visa and did not have a valid travel document. And most particularly, it impacted diversity visas, which there's 50,000 that are allocated for diversity visas. And so it would have, really impacted them. Wait a minute, here is a quick question. So it's a 60-day suspension of permanent resident entries. and does not affect non-immigrant visa holders yet, and permanent residents within the United States. So I think there's a couple of questions. So let me see what the question is on chat. Oh, you can't hear audio? How about now? Can everybody hear? Very low? Okay, let me try to turn up. Can you hear now? Okay, good. Only a few people are saying that they can't hear. So you may have to turn up the volume on your audio because other people state that they can. So if you can do that, that would be great. Somebody's asking about, can we use the automatic revalidation rule in the current scenario to travel to Canada and quarantine 2 weeks and come back to the US via flight? You know, unless it is, first of all, there's certain restrictions for Canada, travel to Canada and Mexico right now. And the other thing is I would curtail any travel outside the US unless it's absolutely necessary, because you know, these restrictions are a moving target. And so, you know, it's important that, you know, you travel with tremendous caution. So the proclamation came out, you know, specifically for green card holders who are or prospective green card holders who are residing outside the United States. But there's a number of exemptions. So, you know, even if you're an intending permanent resident, if you're an EB-5 investor, you're not affected. That means EB-5 investor and their children. Spouses of US citizens are not affected. Children of US citizens under the age of 21. Prospective, you know, adoptees, and individual who are crucial to law enforcement. Certain healthcare workers are exempted, and special immigrant visa holders. Now, somebody is raising their hand, so let me see what the question is. And those who want to, okay, so this rule affects only those who are outside the United States and intend to come into the US as permanent residents. Now, if they've already got a visa by April 23rd of the effective date of the proclamation, then it may not affect them. It's only those, because remember, there's other travel restrictions in addition to the immigration travel restriction. And remember that the consulates have been closed for some time, so people have not been able to visa process for some time. And it does not apply to somebody asked, hi, if someone is on an L1, can they travel? Currently, it does not apply to non-immigrant visas. It's only certain types of non-immigrant visas that are entering the US, with the exceptions outlined here. Having said that, so if you're a permanent resident, there are no travel restrictions. If you are living in the United States, currently there are no travel restrictions. But like I said, I wouldn't travel on advanced parole because you don't know, you know, like I said, this is a dynamic, you know, restrict, and I'll tell you why in a minute. There's a provision within there that makes me want to be really cautious about traveling during this time. If you've got a permanent resident in process and you're living and traveling abroad, you cannot enter with a new approval during the 60-day period. Non-immigrant visas, there are no current restrictions, but they will have the ability to review soon. So, and remember that the 60-day period can be extended. let me see there. This is what happens when, sorry about that. I had thought I had put in, okay, so there's a provision within the proclamation that says that within 30 days, DOL and USCIS will review to see how it impacts, especially with the high unemployment rate, how it impacts other non-immigrant visas. The interesting thing is there's a slack between the stated goals and the chosen means. So they did give a nod to the disadvantaged groups, but and they specifically talked about how when you're going through permanent residence, especially through the PERM process, that they where you have to test the labor market, that it has taken place a long time ago in reference to what the current market is now. Now, having said that, the issue is going to be that it's not a, employment is not a zero-sum game. In other words, just because a U.S. worker is available doesn't mean that that U.S. worker can actually perform the work that we are looking for. It may be some specialized skills. And we saw that was really a problem during the TARP funding. So during TARP, that's the Troubled Asset Relief Program that banks, during the bank bailout, they had instituted some additional requirements for bailout money, saying that you've got to test the labor market, you have to make an attestation. So what happened was a lot of banks didn't want to go through that extra hassle in hiring new H-1B workers. So it applied to new hires. So what they started doing then was the banks then started hiring or outsourcing their IT needs. So if you think you've got, if these businesses are troubled, and that's why they're seeking some type of relief funding, the biggest concern, like I said, during the TARP time was you're not giving the banks the requisite skilled labor needed to address the issue. So when the standard process for permanent residency is 3 stages. First, you're filing with the Department of Labor. Second, you're filing an immigrant petition with the USCIS. And when a visa number is available, you'll be able to undertake the final process in which you can adjust your status from that of a non-immigrant to a permanent resident. I have a question, so let me see what the question is. My H-1B max is out, ending by May 24th, 2020, and the I-94 June 3rd, 2020. My PERM is in progress. What do I need to maintain status while I won't be able to travel due to travel restrictions? Okay. The H-1Bs, the maximum allowed period for H-1Bs is 6 years. The only way to extend the H-1B beyond the 6 years is if you're in a particular place within the permanent resident process. So, as I said, there are 3 stages. The first stage with the Department of Labor is called PERM. Then you file what's called an I-140 with the USCIS, where the PERM that's filed with the Department of Labor is trying to make sure that you're testing the labor market, that there's no strike and lockout, that, so it's basically gauging the job, making sure that the proper wage is assessed. Once that's certified, then you file with the I-140 with the USCIS. The USCIS then looks to make sure that that the individual has the education and experience that's required for the degree, And then B, that the employer has the ability to pay the employee the required wages. So if the I-140 is approved, then you can obtain, and you're not able to adjust status to that of a permanent resident because there's not a visa available. You know, there's only a certain number of immigrant visas that are allocated per year. And that's, you know, divided up per country. Those countries that have the largest number of people immigrating to the US have backlogs, some as many as 12 years. So if you're able to do stage 1 and stage 2, but you're not able to leverage stage 3 because there's not an available visa number, then you're able to extend your H-1B beyond the 6 years in 3-year increments. But the I-140 has to be approved. Now, there is another mechanism in which you can extend your H-1B beyond the 6 years. If your PERM and or I-140 has been pending for more than 1 year. If your PERM and I-140 has been pending for more than 1 year, then you're able to get extensions in 1-year increments. Now, the 6 years max on an H-1B does not include any time that you spent outside the United States. So 6 years max is only for the period you've been in H-1B status in the US. So if you spent some time outside the United States, you can file an extension for what we call buyback time, time that you're buying back for periods you're outside the United States. If you don't have any buyback time, you would need to, in order to maintain valid status, you would need to change status to another non-immigrant category, like a student visa or a visitor visa. Visitor visa, neither the student visa nor the visitor visa will allow you to continue working in most cases, but definitely not the visitor visa. But it would maintain valid status as long as you file it prior to the expiration if you are unable to travel. We are in the recruitment stage of the PERM. Can we go ahead and file the PERM? You should be able to. Let me tell you some things to look out for while you're undertaking the PERM process. The last question is, I've got an RFE on February 4th for my visa extension. Due date is May 1st. We're preparing RFE documents. Last week, I got a denial on the notice saying, did not receive RFE. What do I have to do? It must be a USCIS error. I'm going to assume that the RFE is for an H1. And if it is, you should have filed it. I would have filed it through FedEx. You know, you have either FedEx tracking or whatever mail you use, there should be a tracking mechanism. I know that we commonly use FedEx because that way we can combat that by stating, okay, here is proof that it was received. Here's a couple of questions here, and I'm going to answer these, and then what I'm going to do is go forward with the seminar, and I'll answer all the questions at the end, because so that you understand what because so it, you know, the seminar reads smoothly. Okay, if you have automatically received a stimulus check, will this be considered a public charge and go against a PERM application? No, but they will assess the totality. They have stated that, you know, the stimulus money should not be one of those that is considered over as a public charge. And they've treated it as more of a tax rebate, tax abatement than anything else. So it should not be, but like I said, this is so because they outlined that it would not be when they issued the CARES, the different benefits under the CARES Act, that, you know, they can't go back later and say, you got it, so we got you. So I think that you should be fine in that respect. I am on OPT, came to India for vacation. Do I get, he says, do I get effect due to the suspension of immigration to the US? Are you affected? Currently, you're not. If you are able to come back and you've got a, you know, it's never good to travel while you're on OPT because there's a lot of discretion that they can use when you're re-entering, and you know, most likely in this current economic climate, they'd want to make sure that you still got employment here in the United States. So it is always advisable not to travel on OPT, but the current President's Proclamation does not address that directly. My labor got approved. Will I be able to start my I-140? My employer is a university. Yes, you will be able to file your I-140. After the approval of I-20 without backflow, after approval of the well, the I-20s are still getting issued. I think most universities, what they're doing is, even though most of the universities, the DSO office is closed, they're still processing. They will probably just send that to you electronically, which is permitted right now. My PERM was priority date was in February, and it was supposed to take 4 months. What kind of delays can I expect? I was not clear on the previous discussion. Can an EAD travel in? Is an EAD holder, I guess, who has a visa, can they travel within the 60-day entry ban period? Yes, but remember I said that there is a provision within the President's Proclamation where they're going to ask USCIS and DOL to address any additional restrictions. So I would be cautious of any travel during this time. You have, you know, in various cases in the past, you know, it's a lot more difficult to impute restrictions on people who are already in the United States. There's a detrimental reliance issue and a whole bunch of other issues. So it's easier to equate the ban of entry rather than imposing restrictions on those who are already here. So I would not travel. If an EAD people lose their job, can they apply for unemployment benefits? Will it be a public charge? No, it would not. So like I said, I'm going to hold off on a couple of other questions until the end so we can go through this, just so that you can understand this through the continuity of the subject matter. So as I said, with the permanent residence process, there's Department of Labor. Then there's the I-140, where you have to prove Department of Labor, they're testing the labor market, and you know, they're placing an ad, job postings, the like. And then on the I-140 stage, you have to prove that you've got the education and experience prior to joining the employer, with the exception, few exceptions, even if you got the experience at the same employer. But the other thing they look at is ability to pay. So first, for PERM applications, remember, they're going to be issued electronically to June 30th. And so, and they are giving employers the ability, because you have to place a notice of posting at the work site. So they're allowing for the quarantine period, you know, for employers to be able to do that after the quarantine period. And any responses to the Department of Labor in terms of audits and so forth are given an additional time period till May 12th, 2020. And we covered this in one of our previous YouTubes in greater detail. But some of the things I wanted to talk about is, you know, how a reduction in workforce could affect your PERM process. So these are the deadline extensions for the Department of Labor during this time period. So here is the issue. I'm going to start with the bottom and then I'll go to the top. Reduction in workforce. There are very specific restrictions for filing a PERM, for an employer to be able to file a PERM on behalf of an employee if there has been a reduction in workforce. So that's something you want to really look out for. So if your employer, you know, because you're an H-1B visa holder, did not eliminate your job, but may have eliminated other jobs that are similar to yours, that could have an impact on your PERM application. The exception being, so if you're a systems analyst and you're located in Richmond, Virginia, and the PERM was filed for a systems analyst in Richmond, Virginia, but your employer has since terminated or reduced their workforce with systems analysts in Richmond, Virginia, then that would impact your PERM for a 6-month period. But if you are filing the PERM, because PERM is filed for prospective employment, not current employment. So if your PERM was filed for project lead in Richmond, Virginia, and the employer has not reduced their workforce in any of the project leads, then that would not impact your PERM application. If your employer has multiple offices and they, you're a systems analyst, you filed a PERM for a systems analyst in Richmond, Virginia, but they eliminated, they had a reduction in workforce of systems analysts in Raleigh, North Carolina, that would not impact your PERM. But those are the two things you need to look for if there's a reduction in workforce. The other issue is, this is with Department of Labor, this is the PERM. Remember, phase 2 is the I-140 with the USCIS, where they're trying to look for ability to pay. The USCIS uses 3 types of different evidence for the employer to demonstrate they have the ability to pay. One is whatever the prevailing wage is that's stated on the PERM, stage 1, that the employer's tax returns show that its net income is greater than whatever the salary is stated for that particular position. That's one. Another way the employer can show that is even if the net income is not at least equal to or higher than the salary offered on the PERM, then if their net current assets, that means the net current assets minus the net current liabilities are greater than whatever the salary is being offered to the on the PERM. The third way, and the most common way, is if the employer has been paying the foreign national who is applying for PERM that salary. So if the salary is stated as $60,000 and your employer has been paying you $60,000, then it may, the employer, even if their net current assets don't support it, even if their net income doesn't support it, can demonstrate ability to pay just based on the fact that they have been paying their salary. Now, some of the things that you worry about is, for example, on the H-1B, because remember, it's prospective employment, right? So on the H-1B, you may have been paid $80,000, and but because you have a recent, promotion or something, you've gotten a boost to maybe, let's say, $80,000. So on the H-1B side, you're compliant because you have to pay the higher of the actual wage or the prevailing wage. So the actual wage is what you pay other H-1B, other similarly situated workers with the same education and degree, and the employer's comporting with that. But your PERM that's being filed, the salary offered on the PERM is $80,000, right? And let's say during this COVID incident, because your employer is having some challenges in the business realm, economic issues, and they want to reduce your salary, still adhering to the wages stated on the H-1B, but yet less than what the PERM application may be stating. They can do that. I mean, that's not a problem. If there's some things, you know, from a compliance perspective that they would have to do. But what that could impact is if the employer's tax returns are showing a negative, and if your salary is reduced from the 80,000 to 70,000, then they would not be able to show that they have been paying you the proffered wage, and therefore they have the ability to pay the proffered wage. That's also the case if you decide to take a 60-day grace period and not take salary for that time, or personal leave, or amend your status from, you know, full-time to part-time, because your salary would be less than what the PERM wage would require, and that may be problematic on your I-140. Let me say this again. At the I-140 stage, you have to be able to demonstrate, the employer has to demonstrate that he has the ability to pay your salary. They can do that through the net income and showing that the net income is equivalent to whatever salary is offered. In this example, we said 80,000. They can show that the net current assets minus net current liabilities is either 80,000 or greater. Or the most common way is if they are paying the employee whatever the proffered wage is on the PERM, because you have to demonstrate that you are able to pay the proffered wage from the date of filing all the way through the I-140. So if your salary is reduced, either because you took personal leave, you're leveraging the 60-day grace period, or you've been amended your status from full-time to part-time, or the employer reduced your salary and is still compliant with the H-1B, you may have an ability to pay issue. And I would just encourage you to look into that. And if you've got questions specifically on that, email us at info@challalaw.com. Now, remember, when you're going through the permanent residence requirement, you know, you have to demonstrate that you're not going to be a public charge. So somebody had asked earlier about unemployment benefits. Unemployment benefits are an earned benefit, so they don't, they wouldn't come under the public charge issue. And for the most part, you know, emergency medical assistance on COVID or small business administration loan programs, you know, they have said clearly that, you know, that would not be part of the equation because they're not considered public benefits. But they will, the USCIS will look at the totality of the situation. And if you at that time don't have a job, or you know, there's some other issues that would impact their consideration in looking at whether you are a public charge, and that could be problematic. And what they look to is a health, age, family status. They will also assess resources and so forth, education and skills, and the expected period of admission, and if applicable, the affidavit of support sufficiency. So, you know, although, you know, the certain benefits are not deemed to be a public charge, it could impact their analysis. So it's just something to keep in mind. The USCIS has announced that they would extend their, you know, closure. So the agency is readying offices to reopen in compliance with latent state orders on or after June 4th. All appointments will be rescheduled, and InfoPass or other appointments may reschedule via the USCIS contact center. Remember, they are backlogged. So you can expect serious delays in securing appointments, or you know, getting your, if you were applying for naturalization, getting your naturalization interview scheduled and so forth. Let me see. I'm going to start answering some questions now. EAD is expiring 6/8/20. I've already filed for an extension and the green card application in February 2020. I started a new job in April. Is there any way to expedite the extension? No, but if you've already had an EAD before, if you remember on our last program, or if you haven't, please, you can go ahead and listen to it on our YouTube channel, that they are not redoing biometrics. So that would, this particular EAD without, they're going to use your old biometrics. So it should be processed fairly quickly. I have an approved I-140 and an I-45 pending. I'm now working 3 days a week with a reduced salary, but as a labor certification requirements. Can we apply for partial unemployment with North Carolina and the CARES Act? Unemployment benefits are earned benefits, so you are eligible to file for that. As I stated, the only concern I would have is even though your I-140 is approved for ability to pay, when and if you have your interview, because remember, for the labor certification process, you have to have an offer of full-time employment. So you want to make sure that by the time you have your interview, you have an offer of full-time employment. And so if there's no indication at that time that your part-time work would not be converted to full-time, that may be a problem. If an EAD holder loses their job, are they out of status? It depends on if it's an EAD holder that is on an H-4. An EAD is an employment authorization document. You can get the employment authorization document for a number of different reasons. If you are a particular dependent and you're like either on an L, an E, an H-1B, if the H-1B primary H-1B visa holders I-140 is approved, then the fact that you lost your job on your employment authorization document doesn't necessarily have a status implication, because your status is tied to your primary individuals. For OPTs, that's a different story. And we talked about it in our last session that there's a certain period that you can remain unemployed on OPT and then STEM OPT. But if you are an H-4 or an L-2 that's lost their job, that does not impact your status. I'm on an L extension, lost my job during COVID. I have an approved H-1B master's cap approved 2019 through the same company which holds my H-1B. Would it be possible to transfer to another company for a similar job, even though it is not active? If you have an approved H-1B in the US, yes. You haven't leveraged it. There have been some RFEs that have come up the pipeline about that issue, but we've been able to argue that it's vested with you, and therefore you would be able to transfer that to another company. After the labor certification is approved without backflow for the I-140, I don't have enough time, few months left until the end of the 6 years. What happens and what should I do? Okay. If your H-1B, if your labor certification is approved, you're maxing them out on your 6 years. And because premium processing is still not activated and the I-140s are taking a longer time, if you don't have an approved I-140, you could extend still. It depends. Calculate the time from your labor certification and how long your I-140 has been pending. If your I-140 and labor certification are pending for at least 1 year, you can extend your H-1B beyond the 6 years for at least 1 year. And if you have spent any time outside the United States, in addition, you can apply for extension based on the buyback time. If your labor certification in I-140 has not been pending for more than 1 year and you do not have any buyback time, you need to change your status to either F1 or that would be a more, I guess, a more permanent solution than a B1, because a B1, you know, you wouldn't be able to stay for an extended period of time. I am on an H-1B and planning to go to Canada for stamping. What's the success rate of stamping? I plan to go in a year or next year. It depends. There are different, Ottawa and other places, some of them are easier than others. Not all Canadian US consulates in Canada are the same. In addition, it depends on your background. You know, your degree. We've seen that certain consulates in Canada have a real issue with, if you've got a solid US master's degree, you should not have a problem. If you have a bachelor's degree plus maybe some other 1 year, you know, master's programs in India, I don't know if they are what they would consider valid, if they're, you know, valid programs under their eyes. So there is a mechanism in which you can check it, and then, you know, have you ever had any lapse of status? What kind of employer do you have? Are you working for a staffing agency? Are you working for a USN client? Those are some of the things, those are some of the issues I would look to before making a decision to go to Canada and get the stamping there. PERM was submitted for labor certification in February. When should I expect a response given the potential delays and the result of the crisis? I think they were previously taking 6 months, so you could probably see, you know, and I couldn't even tell you when to expect the delay, but, you know, anywhere from 8 to 9 months right now. If the primary EAD holder lost a job and does not have a valid H-1B, then is he out of status and for how long? If you don't have a valid H-1B, I don't know what your current status is, and I would need to know that before I am able to answer your question, because, you know, it depends on whether you are currently in the adjustment of status process and you didn't maintain your H-1B, and so you're working on your EAD. If that's the case, there is no requirement per se, but, you know, when you are in the permanent residence process, you will have to have an interview, and they want to make sure that you have and continue to have full-time employment. Now, if you've, if your I-485, your adjustment of status has been pending for more than 6 months, 180 days, you can look for another employer for same or similar employment. And so you would still be able to be successful on your permanent residence process, but you must have an offer of permanent employment. In case there's an I-140 pending beyond 6 years, can we wait for a few months beyond the H-1B on another visa and then can apply again for the extension once the I-140 is approved without going through CAP? Yes, you can. You can change your status to that of an F1. Once the I-140 is approved, you would then be able to leverage your extension beyond the 6 years. And remember that if the I-140 is pending and the labor certification is pending for 1 year, then you can get the extension based on that as well. Okay, and now I think we've got I'm getting questions on chat, and so let me look at the chat questions now. Um, okay. Do we have any updates for Social Security applications for F1? Not yet. I just checked this morning. No updates on how they're going to process that, and no updates. I was hoping for something for those whose OPT would be expiring this summer to see if there was any relief, and I have not seen that yet. If an H-4 EAD loses their job and apply for unemployment benefits, will it be a public charge? No. Is there any way denied cases can be reconsidered due to COVID issue? They have not provided any mechanism that way yet. So no, because why is the case being denied is the question. If the case is being denied because there's a change in the industry, the economics with businesses now, then you may even try to refile and see if you could get an approval on a refile versus the denial. So, and if it's an extension, do you still have a valid visa? There's a lot of considerations to look into. It's hard to really give you a blanket answer without knowing the facts, but you can email us at info@challalaw.com with your information, and we'll try to get you an answer on that. I probably have to look at the denial letter to give you a better assessment. I'm on an H-1B planning to go to Canada for stamping. I think I had answered your questions when it was on the Q&A. And let me see, do we expect any suspension of L1s? No, I don't. I think it would be very hard pressed for the USCIS. Yes, the president has broad powers pursuant to 1182, but if you remember, some of the travel bans that the president tried to institute previously were struck down. There has to be a relationship between what the immigration restriction is doing and the effect. So you can't just, so you'd have to be able to tie it together in order for it to stand. And there's going to be challenges. If there's there's going to be judicial challenges to any restrictions. But with the L1, especially an executive role, you're not displacing US workers because you are expanding into the US and creating an economic benefit. So I would be hard pressed to think that would be impacted at all. And there's still no word on when premium processing is going to be instituted. My H-1B is maxing out in July. I-140 will be filed this week. Do we have any information? No. My current petition, I-94, is expiring on April 30th. Extension is already filed and received. Can I continue work? Yeah, yes. If you file a timely extension, you have 240 days in which you can work in the United States. So but it can only 240 days or your allotted period. So even though 240 days is permitted, because your H maxes out in July, you can't work past the July date. And again, I would, for those who, because premium processing is suspended, look to see how long your PERM and I-140 in totality have been pending. What's the difference between the H-1 and TN? I'm in the process of getting a new job, but the employer is not willing to provide a sponsorship visa. How will this impact my full-time employment in the US? Well, if you're Canadian or if you're from Canada or Mexico, there is a treaty-based visa called a TN. It is limited in scope to only certain occupations and limited in scope to what the individual needs to have in order to obtain a TN. And so if you would like, please email us. And so in order for you to be eligible to work, you have to have an offer of full-time employment. There are greater obligations with the H-1B than the TN. So I would think that most employers would be willing to at least give a letter of support for the TN, whereas they don't have to really, with an H-1B, they are the petitioner. They would be sponsoring you. So I would think that they would be, if you're a Canadian, if you fall under the some of the professions that are outlined in the NAFTA treaty, then you would be able to, you may be able to easily get the employer to provide the support for the TN, which is very de minimis. Do we expect any other non-immigrant visa from the DHS? Yeah, so they said that they would look at non-immigrant visas in the next 60 days. I don't think that it would necessarily affect L1s, as I had stated previously. So I would, I wouldn't worry about Ls who are already here in the United States, especially L executives. But they may tie, if they do it like TARP, they may tie TARP with hiring H-1Bs if you're at a certain percentage. We just have to wait and see. I mean, we don't know. And if there's enough, and even if there is, if it's not narrowly constructed, even if there's new restrictions and it's not narrowly constructed, there is going to be, some lawsuits filed trying to curb it. So if you're not subscribed to our newsletter, please do so, because that way you will get the latest updates as and when they're happening. Email info@challalaw.com, and we try to push out this information as soon as we get it. And in addition to the weekly webinars, we'll be having other types of information available on our YouTube channel. Here's another, I have a new job and they're filing my H-1B because there's a backlog. The job location is in some other state. Because of the COVID situation, I may be working remotely after the approval. Do you think there would be a need for an H-1B amendment? It depends. If they file an H-1B with both your remote location and the new location on the LCA, and citing that you would go to the new location after the restrictions within the state, then no, you wouldn't need to file an amended because you've already outlined that in your initial petition. If they don't outline it in the initial petition, then they would need to file an amendment. My current, can I continue? Okay, I've already, some people have asked both on the Q&A and on chat. So the ones I've already answered on chat, I don't need to answer again on Q&A. The executive order has some say on the PERM processing route to green card. Because of this, EB2 more favorable than the ones we apply using PERM. Also, do you think the I-140 expedited processing will be resumed? Last, can I apply for an I-140 and 45 together, even if the visa bulletin is not current? Will my spouse get an EAD if I apply on I-145 together? I am on an H-1B visa. This is an awesome webinar. Well, great. I'm glad you find the webinar awesome. So number one, the executive order only pertains to those that are outside the US and are trying to enter as a permanent resident. It does not affect those who are currently here on a permanent resident. The question is, EB2 more favorable when we apply for FIRM? You have to, so for those who don't know, when you're filing an employment-based process, of the numbers that are allocated per country, they're then divided out between the various pathways to getting permanent residence. So there's employment-based first preference, employment-based, which is extraordinary ability, multinational managers, outstanding researchers and professors. Very few people fall into that category. So there is somewhat of a backlog now, but not as much of a backlog as it is for other categories. Employment-based second preference are for those positions that require a master's degree or a bachelor plus 5 years of experience. You have to, not only do you, the individual applying has to qualify for that, but not all positions will support, you know, an EB2 classification. And we're going to be doing another YouTube on PERM, the PERM process, just general PERM process, not in relation to COVID. So you'll be able to see in detail what I mean by that. I'm not sure when the premium processing will be expedited, and you can't file for the I-140 and I-45 together if you don't have an available visa number. But once your I-140 is approved, since you're on an H-1B, your spouse would then be eligible if it is still, if there's nothing that restricts H-4s from getting an EAD, they would be eligible for the EAD. When switching jobs from I-140 from the previous employer, will there be any issue if the I-140 is not obtained in the new company within 3 years of the H-1B? No, if you've got an I-140 from a previous employer, you can change employers and continue to get extensions based on your I-140. In addition, your I-140, once it's approved, you get a priority date. That priority date is vested with you. You get, that is your priority date, even if you change employers. Now, if you change employers, you still have to go through the PERM process all over again, but you're able to get extensions on your previously approved I-140, and your I-140 priority date is vested with you. So even if you file with the new employer, let's say your previous I-140 was filed under employment-based third preference. You know, we went over first preference and employment-based second preference. Employment-based third preference is where the vast majority of people file. It's for positions that require, at minimum, either a bachelor's degree or it requires 2 years of experience. And so if it's filed under employment-based third preference, and now because you've got the job offered is, you know, one that supports an employment-based second preference, and you've got 5 years of experience, so you've got a 4-year degree and 5 years of experience, and you want to file under EB2, your EB3 I-140 priority date can then be ported and used for your EB2. So I hope that answers that question. I think we've got a few more chats, and let me see. Do you recommend regular processing for extensions since we don't know what? Yeah, I mean, one thing is somebody said, do you recommend filing regular processings since we don't have premium processing has not been activated? You can always upgrade. You file under regular processing. Let's say 2 weeks from now, they say premium processing is activated. Then you can, you know, with your receipt notice, you can upgrade with the additional filing fees for premium processing, and then you're able to file, you're able to leverage premium processing. So just because you filed under premium processing doesn't mean you're in any way, you know, hurt by the ability to upgrade later on. And I just wanted to let you know we're continuing our series, and we've got 2 new webinar series that we're going to be doing on Wednesdays, alternating Wednesdays. So on May 6th, we're doing Challa Chai Chats on entrepreneurship, you know, for OPTs who lose a job, you know, how can they work as their own employer, and then what are things that they can do, you know, when they try to apply for the H-1B. So it's not only for the OPT period, what are your plans moving forward? And then if they don't have their own business plan, their own job, can they do that through buying a franchise? So we're gonna have someone, a guest from Transworld, come talk to us about, you know, buying a franchise and trying to make sure that the immigration side and the real world business side are synergetic. So we give you a very clear, outline of what your pathway should be. And on May 13th, we're starting our new webinar on stars and strifes. You know, they always say that if you want to change the narrative, you've got to be part of the discussion. So we want to change this narrative, this negative immigration narrative that you keep hearing a lot of. And how we're going to do that is we're going to highlight some people who have, that are doing some really cutting edge type of, whether it's research or they're starting a new business here or other ways that they are really benefiting the United States, and also highlight some of the challenges they've had within the immigration realm. So that's why the immigration stars and their strifes, their challenges. And later in May, we're going to be talking about the EB-5 mechanism for immigration. And we're going to have someone from one of the regional centers who's, I think he's already executed, I think he's on his 4th project or so, to kind of talk about from the regional center perspective, what it is they do, what that process is like. So I'll be talking about the requirements of the EB-5 and what's needed. And then we'll have somebody who is running an EB-5 regional center to kind of talk about what, from a business side, from their side, what their requirements are. So we're doing all this to hopefully give you some value added resources. And please, subscribe to our YouTube if you liked today. We're doing this every week. Please send it out to your friends list so we can make sure that we're helping as many people as we can navigate through this, current crisis. And as always, I hope you have a great week. This is Lakshmi Challa signing out. See you next week. Bye.